Hi, everybody. Douglas V. Gibbs here. Here's your daily dose. I was at a funeral this morning, as you can kind of tell by how I'm dressed, and get my tie straightened out here. I was at a funeral this morning, and for an aunt who haven't really spent the time with that I should. But anyway, and as I was driving back, from or coming back or finishing the funeral, put it that way, um, got to thinking about the death tax. Is the death tax constitutional? And did a little research, did a little note taking. I know it's not constitutional. There's no authority. Article 1, Section 9, and Article 1, Section 8 basically say that any taxation has to be a direct tax and or indirect tax, cannot be a direct tax, and it has to be in line with the enumeration as based on a census. But and I'll get into that. But so I looked up some different notes and different cases. And the United States Supreme Court upheld said that the estate tax is constitutional in its 1921 decision of the New York Trust Company versus Eisner, arguing that the court didn't adhere to strict constitutionalist view of the Constitution when making its decision, but it has been widely accepted that the estate tax, the death tax, which generally targets the wealthy, is constitutional. It's a Marxist ploy. It's all about redistribution of wealth. It's all about not allowing the wealthy to stay wealthy. Can't hand down private wealth to the next generation down. It's all part of Marxism and the Marxist push. But nonetheless, we've got a court system who has decided it's totally constitutional. Modern federal estate tax issued during the 1916 populist era, I would say also known as the progressive era from late 1800s, maybe 1890s to 1919, and I might even argue as late as the end of the Franklin Delano Roosevelt presidency. And even within its early analyses, the court's ruling skirted key constitutional issues of enumerated power. What that means is enumerated powers means that an authority is given to the federal government according to the Constitution. If it's not given, it's not a power. So the question is the estate tax an enumerated power? No. So, well, Doug, 16th Amendment, that allowed the federal government to tax on income, of the individual. They're gone. So now you got a direct tax on the people who are looking at receiving that income, which had already been taxed, by the way. So now we're looking at double taxation. A recent 6-2 Supreme Court decision in Star Athletica LLC versus Varsity Brands. In that recent decision, Justice Clarence Thomas, who's one of my favorite justices, said that the controlling principle in the case is the basic and unexceptional rule that courts must give effect to the clear meaning of statutes as written. We thus begin and end our inquiry with the text, giving each word its ordinary, contemporary, common meaning. In its 2015 decision, the Comptroller of the Treasury of Maryland versus Wynne, W-Y-N-N-E, where the court struck down a part of Maryland's personal income tax as violating the Constitution's dormant Commerce Clause. Newly appointed Justice Neil Gorsuch, in his first opinion on Supreme Court, relied on the strict meanings of words, the printed text of statutes, and the proper roles of Congress and the courts to aid in his determination that the law passed by Congress to guard against abusive, deceptive, and unfair debt collection methods does not apply to people trying to collect debts owed to themselves. Delivering the court's unanimous decision, Justice Gorsuch noted, "It is never our job to rewrite a constitutionally valid statutory text. With the recent addition of Justice Gorsuch to the bench, who ascribes to an ardent textualist interpretation of the Constitution, constitutionality of the federal estate tax may eventually be ripe for a new review. The federal estate tax lacks a constitutional founding, legitimizing its inclusion in the federal tax code, and infringes on the United States Constitution from a strict constitutionalist viewpoint, which I agree with that. That last part was taken from a study, a paper written by Henry Lowenstein and Catherine Kiska Schultz, a historical examination of the constitutionality of the federal estate tax. All right, now, other information. So now, when you look back at the Federalist Papers, a lot of what the progressives like to refer to would be Federalist Papers number 30 through 36, authored by Alexander Hamilton, in which he argues for a strong federal taxing system, both internal and external taxes, particularly to cover war and natural disasters. Now, Hamilton was a monarchist, big government guy, nationalist. He believed there should be a perpetual national debt as well, because according to him, if there was a perpetual national debt, the states would be less likely to secede from the Union, because they need to pay their share of the debt before they leave. He believed in heavy taxation. Remember the Whiskey Rebellion? That was all because of an additional tax on whiskey by Hamilton, on whiskey that wasn't even going to market. It was being used as a barter in this Kentucky, South Pennsylvania town. And Federalists regarded Hamilton's views as creating a strong central government akin to monarchy, ultimately tyrannical, a situation the Revolution did not wish to duplicate. The framers ultimately drafted a constitution encompassing compromise, furnishing prescriptive language to establish Article 1's first enumerated power of Congress. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. Congress's taxing power reflected the apprehensions of the framers that the federal government's taxing power be strictly limited to two specific categories: import-export taxes, referenced as duties and imposts, and consumption taxes, known as excise taxes. Meanwhile, in Article 1, Section 9, the Constitution strictly prohibits direct taxation and says that no tax shall be laid unless in proportion to the census. Remember, in the old way of collecting income tax was that the states paid it. The budget was sent to the states paid the percentage of the budget based on their population. For example, today, California is 12% of the total population of the United States. Therefore, if the old method was in place, California would pay 12% of the budget, then they would tax the people to replace that money. However, the states would review the budget, and if they didn't like what was in it, they believed it was unconstitutional or ridiculous spending, or that the federal spending was going beyond its constitutional authorities, they would refuse to pay the budget and send the budget back, expecting the federal government to then make adjustments as necessary. That changed with the 16th Amendment. The Founding Fathers did not believe that there should be a direct taxation. In fact, Thomas Jefferson said that if you were to directly tax people, there would be no limit on how much the government could take. And boy, has that been proven true. James Madison, considered the father of the Constitution, faced continual backlash on federal taxes and tax collections while serving as the nation's fourth president. I don't like saying nations, it's country, but okay. In 1813, nearly a quarter century after the ratification of the Constitution and its taxing power to Congress, Madison proposed an increase in excises and imposts to pay for the War of 1812 to preserve the country's credit honor. Madison's own party leaders objected, stating to look upon a tax gatherer as a thief, if not to shoot him as a burglar. 5 years later, Chief Justice John Marshall, who I typically don't like, but in this case, well, even a broken clock is right twice a day. in McCulloch v. Verlin, invoked the premise that the power to tax is the power to destroy. And that came from the historical sketch of the Second War between the United States and the Madisonian Equal Protection by James S. Liebman and Brandon L. Garrett. And yeah, and that's it. So the founding fathers were against this kind of stuff. They were against income tax, direct taxation, and estate tax. They were against that. They didn't allow it. Article 1, Section 9 and Article 1, Section 8 didn't allow it. So when did this begin? Well, let's read from the Act of 1861. Let's read from American Civil War. It's from Encyclopedia Britannica. And let's read David Herbert Donald's book about Lincoln. President Lincoln signed the Revenue Act of 1861, imposing 3% income tax on incomes over $800. Perhaps because of the intensity of citizen loyalty to the Union and dedication to winning the war, the income tax did not incur an immediate constitutional challenge. That challenge, however, arose a decade after its repeal in the 1880 Supreme Court case Springer versus United States, whereby the constitutionality of the income tax, then since amended, was pitted against a state estate tax. That was actually, yeah, that's okay. William Springer argued the Civil War era income tax was an impermissible direct tax on his estate by the federal government, not a portion among the states. Going back to Article 1, Section 9. Then in Elizabeth R. Carter's New Life for the Death Tax Debate article in 2012, we read this: Congress enacted the Revenue Act of 1862, which established a comprehensive estate tax and collection methodology. The law created both an inheritance tax and a stamp tax on the transfer of estates at graduated rates. Increased revenue needs by 1864 caused an increase in rates and the addition of a legacy tax. As was the case with most of the Civil War taxes, Congress repealed these taxes shortly after the war ended: the inheritance tax in 1870 and the stamp tax in 1872. So at the time, they still got it, even though the federal government was trying to impose these taxes. Courts were saying, no, you can't do it. Not that I'm a fan of the courts getting involved in this stuff in the way they did, but if it's criminal activity, then they can. All right. According to repeal of the federal estate and gift tax, will it happen and how will it affect our progressive tax system? By Chris Ann M. Schlachter. We read this: academics have opined that the estate tax historically provided a legitimate means of generating necessary war income. Others have argued that the purpose of the tax was to minimize wealth being amassed by powerful families in an effort to avoid budding aristocracy in the United States, or at least that was the excuse. Redistribution of wealth, keeping the wealthy down, because, the bourgeoisie is dangerous and we want to give to the proletariat, right? It's all Marxist. Then we read Rethinking the Progressive Estate and Gift Tax by Barbara Redman. A federal tax on the ownership of property would, as a direct tax, present genuine constitutional obstacles. The Supreme Court has avoided this impasse by characterizing a tax imposed on the happening of an event, such as transfer of title upon death, as an indirect tax. In its 1921 case, 100 years ago, New York Trust versus Eisner, the court upheld the constitutionality of federal estate tax, holding that an estate tax is an indirect tax rather than a direct tax on a descendant's property. Well, but it's directly taxing the property, even though it may be indirectly taxing the person because the person's dead. it's directly taxing the property, so that makes it a direct tax. So that's a faulty definition, which makes it unconstitutional to tax in that manner. Then we got, according to Knowlton case, the War Revenue Act of 1898, the history of the American Revolution and the framers' constitutional construction was intent to precisely distance the new nation from European and Roman law that had hamstrung government and liberty of citizens, and abuses of which led to the revolution itself. Because we're supposed to be exceptional, an exception to the rule, as unlike Europe as possible, including throughout history. Valerio Leitner, a Traveler's History of Italy, 7th edition, 2004, wrote this: Rome's estate tax history provides a particularly dark example of the estate tax. During the triumvirate of Tiberius Gracchus, the Gracchi, in 133 BC, an estate tax was imposed to limit the size of estates and recapture wealth from landowners. The oppressive tax proved to be unpopular and offensive to the Roman ruling class. A mob led by Scipio Nasica disrupted the Senate and started a riot in which Tiberius Gracchus and 300 of his followers were clubbed to death. His successor, Gaius Gracchus, in 121 BC, was also assassinated along with 3,000 of his followers. These events led to the end of the Roman estate tax experiment of that era. So it was very unpopular in the Roman Republic and Roman Empire as well. Then we've got a continuation of that text, but in a different part of that. The specific limitations of the federal taxing power was intended by the constitutional framers to avoid the Euro-Roman historical liberty infringing history. The framers were clear in their determination that Congress's power was to be strictly limited to consumption or purchase taxes, which they limited to excise and imposts other than income later granted by the 16th Amendment. So once again, more text saying, hey, the death tax is wrong. It's illegal. It's unconstitutional. Then we go on to the New York Trust Company versus Eisner and Theodore Roosevelt and the Progressive Movement, Encyclopedia Britannica, and Korematsu versus the United States. And here's what we got. Under Democratic President Woodrow Wilson, however, Congress and progressives took aim at wealthy individuals, and the Supreme Court found nothing to gain by opposing them, even if that meant a clear misreading of constitutional intent and limited authority. Without sufficient and detailed analysis, the 1921 court presumed the constitutionality of the estate tax would remain. 6 years after the Eisner decision, the court once again took up a case challenging the federal estate tax in Florida versus Mellon. Florida by Parens Patria challenged the constitutionality of the tax, not based on it being beyond the enumerated powers of Congress, but rather that since its state constitution forbade an estate tax, its residents could not receive a credit against a federal estate tax for estate taxes paid. Florida argued Florida cannot place its citizens on an equality with those of other states in respect to the tax in question, and therefore the tax is not uniform throughout the United States as required by Section 8 of Article 1 of the Federal Constitution. Constitution is all about uniformity when it comes to any federal treatment of anything that's stateside. For example, in Article 1, Section 9, and Article 1, Section 8, it talks about like the ports. They have to be all treated equally. The fees have to be equal. The import-export taxes have to be uniform. All right. Knowlton versus Moore and the New York Trust Company versus Eisner. Court refused to delve into a detailed analysis of the constitutionality of the estate tax itself. The tax is clearly, according to Knowlton and Eisner, both of those cases, quote, the tax is clearly constitutional without apportionment, for such a tax has always been treated as a duty or excise. They just gave it a new name because of the particular occasion which gives rise to its levy. Because that particular occasion is death. You know, it's funny because the word particular, they try to sound smart with that word. I don't know if you've ever seen the movie Idiocracy, where the IQ of Americans go so south that they can't even take care of themselves. And a character from our time gets catapulted into that time period. He is of average IQ today, but he's the smartest guy in the world in this future where basically everybody's dumb. And to make themselves smart, the police in that movie use the word particular every chance they get. It's kind of a play on the words, but it cracks me up because they use the word particular in order to look smart. I don't care if it's particular or not, it's unconstitutional. All right. Then according to Tax Foundation and Cost and Consequences of a Federal Estate Tax, an update by the Joint Economic Committee, a detailed analysis and historical context of our national tax policy strongly suggests a fair reading of the Constitution would conclude the federal estate tax is, in fact, unconstitutional as a taxing power not granted by the specific limitations of Article 1 or the 16th Amendment. The 19 Journals of the Continental Congress, Supernote 45, pages 545 through 546, the following is said. The United States of America was born from a revolution against European sovereign-imposed taxation. That issue remained front and center in the Continental Congress, first through the Articles of Confederation, which essentially removed the power of the federal government to tax, raising its revenue by state contribution, which goes back to what I was saying, the way it used to be. The states paid the tax, and they were able to review the budget before doing so. The people were not taxed directly. The structure of the articles proving unworkable, the framers of the Constitution were meticulous in enumerating specific limits upon the power of the central government to tax its citizens. However, beginning in the 20th century, successive Supreme Court benches diverged from the traditional constitutional jurisprudence, advancing the theory that if Congress, as representative of the people, passed new taxes, then it would be up to the voters to require the Congress to reject or repeal them. Populism impinged on constitutional analysis. Hence the danger of democracy. You'll hear me say it all the time. We're not supposed to be a democracy, and democracy is dangerous. There's a great example. Okay, then let's see. Historical challenges to the estate tax have neither the estate tax was neither an excise nor imposed as prescribed in our nation's Constitution. The Supreme Court adhered to its determination that the estate tax is an excise in New York Trust Company versus Eisner without additional detailed analysis. Such dogma has since been maintained through the decades without further re-examination by the court. However, it is clear from a historical perspective that the 1921 Supreme Court failed to follow a strict constructionist constitutional analysis in making its decision. That gets us back to historical examination of the constitutionality of the federal estate tax, page 151 by Henry Lowenstein and Catherine Kiska Schultz. And then finally, from President Gerald R. Ford and his address to joint session of Congress, August 12th, 1974. The estate tax brings to mind the famous admonition of Thomas Jefferson, quoted by Gerald Ford. A government big enough to give you everything you want is a government big enough to take from you everything you have. And in this case, that your children might have as well. The estate tax is unconstitutional. It's a direct tax on property that's already been taxed. Not an income tax because the income had already been taxed, so the 16th Amendment does not apply. Yet, now, the current administration wants to jack it all the way up to 60%. A tax that's not even constitutional, not even legal in the first place. All right, thanks for watching. We'll see you next time. United we stand, combined we kick butt. God bless America, and God bless you. Thank you for watching. Stay constitutional. Don't forget that you can also visit my websites, douglasvgibbs.com, politicalpistachio.com. And there you can also join my email list. You can donate. You can also learn about my books. I have 7 of them and all the other stuff I do, classes and so forth. Until next time, stay constitutional. Thanks for watching.